Hi, I'm Jeffrey Antonelli, founding partner of Antonelli Law. You're probably watching this because you received a letter in the mail about a lawsuit filed against you. The letter probably says you are accused of downloading movies illegally. That company may be Strikethrough Holdings or Malibu Media, or perhaps another company as well. Here at Antonelli Law, we handle cases that involve more than 50 different movie companies that produce both adult and mainstream movies. Most commonly, our cases do involve adult movies. The movies were most likely downloaded, allegedly using BitTorrent software. You're probably wondering what the letter really means, and if you need to do anything about it. Essentially, this is a lawsuit accusing you of copyright infringement. And the answer is yes, you do need to do something about it. The letter you received is legitimate, and if you ignore it, this will escalate. Things will likely get worse for you. In fact, the longer you wait, the fewer options you'll have. Before 30 days have passed, or an earlier date if one was mentioned in the letter you received, you can keep your name anonymous. After 30 days, your name may become public. The great news is we're here to help. Antonelli Law is the premier firm that handles BitTorrent copyright infringement cases. We're the best firm to help because BitTorrent copyright defense is a unique area of law. So you should have an attorney who is experienced in this area. We are America's most experienced BitTorrent copyright defense firm. We've handled nearly 3,000 cases of this type since 2011 all across the country. We explain all of your options in a clear, easy-to-understand way and answer all of your questions. We'll guide you through the process step by step. We take on these cases in every state in the United States where these film companies file lawsuits. While lawyers typically work only in one or two states, we are able to work nationally because these are federal cases involving federal law. So we've had clients in New York, California, Hawaii, and many more. We understand that getting sued can be stressful, but we can help you through it. Most of all, we'll get you the best possible outcome. With our experience and expertise in the area of BitTorrent copyright infringement law, we're confident you'll get results that are as good or better than would be delivered by any other law firm in the United States. We don't provide cookie-cutter answers. Every case is different, and we'll work with you, whatever your circumstances, so you pay as little as possible. In addition, our legal fees are reasonable. Sometimes we work on a sliding scale and adjust our rates to a fee that makes sense for your situation. And we're happy to say we've had many happy clients. Here are just a few short excerpts from testimonials from satisfied clients. In addition, we offer free confidential consultations to anyone being sued to help you decide how you'd like to move forward. We'll get into a lot more detail soon. But if you'd like to contact us now for a confidential consultation on your situation, here's how. Let's go over this from the beginning. If you're watching this, you've likely been notified that your internet service provider served you with a subpoena. This means you received a letter that says you're about to be sued for illegally downloading adult films or mainstream films. The letter came from your internet service providers such as Comcast, RCN, AT&T, Fios, Cox, etc. You would have also received a copy of a subpoena issued from an attorney representing Strikethrough Holdings, Malibu Media, or some other company. This means one of the companies is accusing you or someone in your household of illegally downloading their content without paying for it. First of all, you're probably wondering if this is real. Yes, it's real, and it's not a scam. In a nutshell, you are being sued for copyright infringement in federal court. So let's take a step back, and I'll explain three things. First, I'll explain who the companies are who likely sent the subpoena. Then I'll explain what they think you did. Then I'll explain how they found you, and then I'll explain what they want. After we've been through all of that, I'll explain what you can do about it. Let's get started. So first, who are these companies? The letter you got is probably from one of two companies, either Strikethrough Holdings or Malibu Media, possibly from another movie company. They are the companies who produce the adult movies that the lawsuit alleges you illegally downloaded. Strikethrough Holdings adult films are published under the subscription sites Blacked, Vixen, and Tushy. Malibu Media's adult films are published under the subscription site x-art.com. You may or may not have heard of these. Second, what do they think you did? These companies are claiming you downloaded their adult movies illegally using BitTorrent technology. Maybe you did and maybe you didn't, but they're claiming you did. And it's likely they think you've downloaded a bunch of adult movies, not just one or two. From a legal standpoint, the issue is not that it's adult content. It's that you allegedly downloaded these movies illegally using software without paying a license fee. Essentially, Strikethrough Holdings or Malibu Media is accusing you of copyright infringement. If it's been fewer than 30 days since you received the letter, Strikethrough Holdings, Malibu Media, or whatever company is accusing you of illegally downloading the movies does not have your name. So 3, how did they find you? The answer in short is they found you through your IP or Internet Protocol address. That's the unique code assigned to your internet connection. At this point, your internet provider knows who you are, but the movie company does not. Here's how it works. Each internet connection has something called an IP address that's specific to that connection. The companies whose website you visit can see the IP addresses that have been on their sites and have downloaded their content. Through the IP address, they're also able to figure out who provides the internet to your home, such as Comcast, RCN, Verizon, AT&T, Cox, etc. It's sort of like when you text someone, they can see your phone number even if they don't know who you are. And then they can text you back to that same number without knowing your name. And last, what do they want? These companies look for illegal downloads of their adult content so they can sue the people who did it. They call this enforcing their copyrights. Their ultimate goal is to sue you for allegedly downloading their content without proper licensing. Again, it's a federal copyright infringement lawsuit in federal court. What they specifically want right now is your personal information, such as your name and address. The letter you got is your internet provider letting you know your personal information is being requested. Before your internet provider releases this information, they send you the subpoena. Now that you understand what's going on, let's talk about what you can do about it. First, I'll explain why you should not ignore it. Then I'll explain what your options are. Probably the first thing you want to know is, can you ignore the letter? The answer is no, do not ignore it. When you first receive this letter, you are still anonymous, meaning Strikethrough Holdings or Malibu Media does not know your name. Yet. The court and Strikethrough Holdings or Malibu Media still know you as just John Doe. However, if you ignore the subpoena, your internet service provider will likely release your name to Strikethrough Holdings or Malibu Media. Once the company has your name, in almost all cases, they will amend the complaint in the public court documents from John Doe to your actual name. Your name will then be out in the public sphere. You will next be served with a court summons. Under no circumstances should you ever ignore a court summons. Many clients don't mind losing their anonymity, though obviously some do. The other issue, though, is that if you ignore your subpoena and then receive a court summons, your options moving forward are limited. You'll lose some of your negotiating power, but certainly not all. Typically, you have 30 days or less from the day you receive the notification to decide how you want to handle your case. The longer you wait, the fewer options you'll have. If you wait for the 30 days to go by, your name may become public and you may be served with a court summons. Then you're under the jurisdiction of the federal court. So now that you know you should not ignore the subpoena, let's discuss your options. So first, before I get into what you can do, I'm going to tell you what not to do. Then I'll go over your three options. One option is to remain anonymous to the public and settle your case. Your name will not appear in any public court documents. Another option is to file a motion to quash the subpoena. At that point, you will still be anonymous. And your third option is to fight back in court. So again, before getting into your options for how to address your subpoena, here's what you should not do. First, do not sign anything without legal representation. You may be signing away some of your options and ability to negotiate. Second, do not try to delete anything off your computer. This could make your penalties much worse. Now that you know what you shouldn't do, here are your options for what you can do. Your first option is to remain anonymous and to settle. This is the way to resolve your case without your name ever being made public. Settling can resolve the situation quickly and buy you peace of mind. If you settle through Antonelli law, we will assure you can make the payment anonymously. Your name will not be made public, so your name won't be associated with breaking the law or anything to do with adult movies. In addition, we'll provide future protection. We'll ensure that you are released so you cannot be sued again by the same movie company for any other supposed download activity that happened prior to your settlement date. And we also protect everyone in your household. For example, let's say you are the internet subscriber, meaning the bill's under your name, but someone else in your home allegedly downloaded the movies. In this case, everyone would be released from liability. Unfortunately, this also means that you will have to pay a settlement fee, even if you personally didn't do anything wrong. The amount you will have to pay depends on your situation, and there's something of a sliding scale. No matter what the circumstances are, we here at Antonelli Law will give you the best settlement possible. We've had success with reducing settlement fees by over 90% in some extreme cases. This is because we have extensive experience with Strikethrough Holdings and Malibu Media, as well as with this type of copyright infringement law in general. In addition, we're savvy and aggressive negotiators who will do everything we can to keep your settlement amount low. So even though you'd have to pay a settlement fee, many of our clients feel the ability to ensure their anonymity and end the process is worth the fee. As I mentioned before, if you want to fight the suit, you have two options. You can file a motion to quash or fight the suit in court. Even if you know you didn't do it, unfortunately, you're still going to be sued since the company thinks you downloaded the movies illegally. In addition, the court believes there's enough evidence for the case to proceed at this stage of the lawsuit. So let's start by talking about filing a motion to quash the subpoena. Filing a motion to quash is essentially telling the court that the complaint against you cannot stand up in court. In other words, it's an effort to convince the court to throw out the lawsuit. Motions to quash are tricky. They can work in some circumstances, but not all. The great thing about a motion to quash is that if you win, your case can get thrown out and you won't have to pay any settlement fee at all. There are multiple reasons a case could be thrown out. Most often, they're related to the movie company having bad information. The technology the movie companies use is good, but certainly not infallible. This is rare, though, so making a motion to quash is a risk. And even if you win a motion to quash, the movie company will probably have the right to file an amended lawsuit against you. If they do, a second motion to quash may need to be filed. Depending on what happens from there, the movie company may appeal the decision to the appellate court. So in the end, you may still get sued. In addition, you may lose your anonymity if the motion is denied. The main thing for you to know, however, is that the circumstances of each case are unique, and Antonelli Law can provide expert advice. We'll let you know if we think you have a chance with a motion to quash, and we can advise you on the pros and cons. Antonelli Law has been successful with multiple motions to quash, and we may be successful in your case too. Now let's talk about fighting the case in court. We've helped many clients fight back against copyright claims in court. We can first advise you as to whether this is the right choice for you. As with all options, we'll review the pros and the cons with you and help you make the decision that's right for you. If fighting in court is the right choice for you, we are tenacious, experienced litigators who will fight hard on your behalf. And remember, these are federal cases, so we can defend you in any federal court anywhere in the United States. If you choose this route, you could win the case and get damages, including legal fees. If you lose, you could end up owing more than the original settlement fee demanded by the movie company. You could also lose your anonymity. We're proud to say we've helped many people settle successfully. We may be able to do that for you too, for thousands of dollars less than the movie company initially demanded. Our courtroom experience, including trials and appeals, allows us to be more effective negotiating a settlement for you. Even though getting a letter in the mail and your name being subpoenaed can be stressful, whoever you are and whatever your circumstances, we can help. Copyright infringement cases, whether involving adult content or not, can be complicated, so we highly recommend hiring a law firm experienced in this field. Antonelli Law is America's most experienced BitTorrent copyright defense firm. We've handled nearly 3,000 cases of this type since 2011. We explain all of your options in a clear, easy-to-understand way and guide you through the process step by step. And we can work in any state in the United States where these movie companies file their federal lawsuits. We understand that getting sued can be stressful, but we'll help you through it. We'll get you the best possible outcome based on your specific situation. And remember, all initial consultations are free and confidential, so don't hesitate to reach out.